Ms. Corbello. I'm Judge Dennis, and Judge Wiener and Judge Duncan are the other two judges on this panel. We're here to hear your case in Jonathan Hitt versus Marcia McLane. So, Ms. Datla, you will be the first to proceed. And let me thank you as court-appointed counsel for serving in this case. I think the court thanks you and the United States thanks you. I wanted to be sure to do that. But thank you, because I forgot to do that on the first case in this series. I feel very badly about that. So you may proceed.
Good morning, Your Honors. As Judge Dennis mentioned, I'm Kirti Datla, and I'm court-appointed counsel for Jonathan Hitt in this appeal, and I've reserved 4 minutes for rebuttal. Although there are several claims at issue in this appeal, there are really just 2 basic sets of issues involved. The first set of issues involves the district court's failure to properly apply well-worn principles about how to construe pro se pleadings at the pleading stage of a case. And the second set of issues involves the district court's misapplication of Article 3 standing requirements after the bench trial that was held in this case. I'd like to start with the first set of issues and to start with the simplest error. And that error has to do with the dismissal of 2 individual capacity claims, one involving an unreasonable seizure claim and the other involving the procedural due process claim. The sole basis for the district court's dismissal of these claims, this is at record 528, was that Mr. Hitt did not adequately plead McLane's involvement in these constitutional violations. And this is also the sole basis on which these claims, the decision below, is defended on appeal. But that conclusion simply can't be squared with the allegations that are provided in Mr. Hitt's amended complaint. And I'd like to highlight 4 allegations that I think are well sufficient, but there are, of course, others in the complaint. First, Jonathan Hitt alleged that McLane had previously decided where he could reside, for example, at his home. That's at record 69, paragraph 16. Second, he alleged that he was summoned to the TCCO offices where he, quote, met McLane, and she, quote, began the meeting by threatening to incarcerate, quote, him in the Travis County Correctional Complex or the TCCC. That's at record 110. Third, he alleged that McLane then visited him after he was transferred to the TCCC and, quote, informed him that she did not even have a policy, quote, that had authorized her actions. That's also at record 110. Fourth and finally, he alleges that McLane is the one who's keeping him confined in the TCCC. That's at record 70, paragraph 20. The clear inference from these allegations is that McLane, who we also alleged is the head of the TCCO, threatened to incarcerate him at the TCCC and then carried out that threat. That's the action that these 2 constitutional claims are based on, and that was all that was needed to plead her involvement and to render and to state a claim against McLane in her individual capacity.
Ms. Datla, that's very helpful. Thank you. The issue of alleging personal involvement of McLane, that I'm trying to keep straight all the different claims in this case, which is a little confusing, but your brief was very helpful. That specifically goes to the 4th Amendment claim. Is that with respect to searches or seizures or what?
These arguments relate only to 2 claims. The first is the 4th Amendment unreasonable seizure claim. Okay,
so that's you had me arrested after the relationship came to light with Lopez. Essentially, you had me arrested and put in restrictive confinement. Is that the gist of that claim?
We can see that there's that clear causal connection, but you had me arrested, taken from my therapist's office to Littlefield. That's the act.
That's the gist, the 4th Amendment.
Exactly. And this also relates to the procedural due process claim, which stems from that same factual set of facts, which is that he was taken from his home to Littlefield without any notice or process before or after.
Now, just so I understand, these are with respect to her personal capacity.
That's correct, because the official.
Yeah, with respect to official capacity, did the procedural due process already go to a bench trial?
Yes, so 3 claims went to a bench trial. The 2 we've been discussing in her official capacity, and also the other Fourth Amendment claim, the unreasonable searches claim.
Right. Did she get relief on, or did he get relief on any of those claims after the bench trial, just so I can understand?
He got relief on one of those claims. That's the procedural due process claim. The district court held that there was a deprivation, and the relief ordered was basically that he ordered McLane to hold some sort of hearing at which Jonathan could present evidence and get a determination on whether this action was lawful.
Has that happened?
So this isn't in the record, but it has happened according to the docket in the Texas State Court case. The hearing was held on September 2019. There has been no decision in that. So he has gotten the hearing, but not the written decision to which Judge Sparks said he was entitled to.
Okay, is he still at, this may not be in the record, but is he still at TCCC?
Yes, it's not in the record, but he's still there.
Okay, thank you.
Certainly. So unless your honors have further questions about these 2 specific individual capacity claims, we can turn to.
Oh, I'm sorry, I do have one other claim. It's not always clear to me where qualified immunity may be involved, may be a live issue. In your view, is qualified immunity a live issue as to either one of those claims? Because there are personal capacity claims. Is it even an issue that's before us? What's your view on that?
So our view is that at this point in the case, there is no qualified immunity issue before this court because, we briefed the issue in the opening brief and explained why we think the law is clearly established. The response brief does not respond to that argument or even ask this court to affirm on that alternative basis. And this court's normal procedure is not to address arguments that are forfeited in this way. And I think that rule carries extra force here because qualified immunity is an affirmative defense that's sort of designed to protect the inconvenience of the defendant. And if the defendant signals, to be frank, that she seems not to care whether this claim goes forward, and we know that these claims in the official capacity have already been taken to a bench trial, so it's not clear that much more needs to happen below. Our position is that this just isn't the kind of case where you would need to go out of your way and make arguments for a party to affirm on that basis.
Yeah, so let's say hypothetically reversed on the lack of personal involvement with respect to these 2 personal capacity claims, the relief would be remand for further proceedings and presumably a QI defense could be raised, I guess. I don't know if it could be or not, but.
I don't want to bind anybody below, but I do think, if there are arguments based on, the record that develops after what happens below, she could conceivably, if she decides at that point to raise qualified immunity, she could conceivably do so, and the judge would decide whether that was proper, whether it had been waived, and if not, we would decide it on the merits.
Okay, thank you.
Certainly. So the next claim I'd like to discuss is it's another individual capacity claim. This is the remaining Fourth Amendment claim. It's the unreasonable searches claim. And to this claim, the argument we make on appeal is that Ms. McLane had every chance to dismiss this claim and make it clear that she wanted this claim dismissed against her in her individual capacity and simply did not. So her first chance to do so was in the motion to dismiss itself, which she styled as a partial motion to dismiss and said she was seeking to dismiss the majority of the claim. So by concession, not a full motion to dismiss. The second chance was after the magistrate judge prompted her to be more specific. And in her reply brief, which is at record 376 to 377, she identifies 3 additional claims, none of which is the unreasonable search claim. And the third chance she had was after the report and recommendation, which recommended dismissing this claim precisely because she did not address it. Which recommended against dismissing the claim precisely because she didn't address it. That's at record 474. And she didn't file an objection, even though the report and recommendation included the standard, notice that if you don't object, you waive your right to review of that claim and to have it heard on appeal. So our view is that she did not seek to dismiss this claim, and thus the district court should not have dismissed it essentially sua sponte. And all of the arguments we were just discussing about how qualified immunity is a defense and needs to be raised would apply to this claim too.
Did she make a personal involvement argument with respect to, I know that she didn't mention this claim in particular. I have a record citation 157 that said she argues she wasn't personally involved in any purported violation of Hitt's constitutional rights.
So I think that the motion to dismiss was written in a very generic sense as to all the claims that it was discussing. And our position is just that she listed the claims that she was seeking to dismiss in both the motion itself and then the additional claims in the reply. And this isn't one of them. So when she uses the phrase all, she's not referring to claims that haven't been specifically listed.
Okay, and I'll ask you about QI on this one too. Is QI, a qualified immunity, presented here as a defense to this searches claim? I assume this one is, the gist of this one is McLane authorized or ordered whatever searches of him while he was not in TCC that were violative of the Fourth Amendment, right?
That they were sort of suspicionless searches carried out in an arbitrary and invasive manner. Right. So I think, again, the reason we don't think that qualified immunity is at issue is because the claim shouldn't have been addressed at the motion to dismiss stage at all. Qualified immunity merits anything because it just wasn't in part of the motion to dismiss.
Okay, thanks.
Let me ask you this. Are you asking us to decide the merits of your client's personal and official capacity substantive due process claims?
So we're not asking you to decide the merits of any of these claims, and I'm happy to turn to the substantive due process claims, which are up next. So there's two substantive due process claims that were raised in the complaint. There were more, but on appeal, there are two substantive due process claims that we're pressing on appeal. And the only basis for the dismissal of these two claims, which I'll articulate more clearly in just a second, but the only basis for dismissal was that the district court said, these are coterminous with your procedural due process claim. And so there's nothing more to be gained from these claims. That's at record 532. And that's just not correct. So here are the two claims. They're both based on the articulation of the rule in selling, which this court has reaffirmed in cases like Brown and earlier this month in Welsh, that when you're in civil commitment, the conditions of your confinement, basically the way you're treated, have to bear a reasonable relationship to the purpose for which you were committed. And under the Texas statute, the purposes here are supervision and treatment such that you can eventually be released from the civil commitment order. So the first substantive due process claim is that essentially that the decision to transfer him from his home to Littlefield had no connection to either of those purposes, to supervision or treatment. And I'll just say the supervision prong has just never been at issue in this case. There's never been any argument that he needed more intensive supervision. And that the treatment rationale isn't present for all of the reasons discussed in the brief, namely that, first, McLane isn't qualified to make these kinds of treatment decisions. There's no, under the allegations in the complaint, there was no involvement of a therapist or any sort of, treatment-based rationale for the decision. So
that's interesting that this is done under the tiered system that was a result of the 2015 amendments to the SVPA.
That's correct.
So he was essentially moved from one tier to a more restrictive tier.
That's correct.
But allegedly by McLane and allegedly because of the relationship that came to light with his chaperone. Right?
At the complaint stage, that's not that's not the rationale that's in the complaint. And I will also just say, according to the testimony of the trial, the only explanation given was sort of something might be wrong. And so I'm just going to bring him in so I can figure it out.
No, I understand. I'm not going to hold you to what my questions. But so what I'm getting at is under the tier system, are you saying that a sort of a medical professional can move a committee from one tier to the other. There has to be a medical rationale for that. Otherwise, it's possible substantive due process violation. Because I mean, obviously, Ms. McLean's not a medical professional. I get that.
Yeah, I think what we're arguing is not for any sort of invasive rule that would require sort of monitoring of how these institutions are run, but just that in this case, the allegation is everything had already been taken care of. You know, I had already been ordered to stop seeing this woman. I had already cut off communications with them. Everybody knew what was involved. And this is from the TCCO's report itself that he attached to the complaint. Mm-hmm. And so the decision to, you know, drastically change my liberty was based on no treatment rationale at all. And so that's really the allegation. And there was, of course, no involvement of a medical professional. So I don't think we're arguing that it has to be the final determinative decision of a medical professional, but in this case, there just wasn't one involved on the allegations of the complaint. Okay. The second due process claim, Judge Wiener just to articulate it, is the claim related to the GPS monitoring. And this one is quite basic. It's that he's confined in the TCCC, which is a high security prison where he's already subject to monitoring by motion detectors, by cameras, by guards. His restrictions are already incredibly limited within, you know, barbed wire fences. And he's being ordered to wear a GPS monitor and to pay for that privilege. And that bears no supervisory or treatment related purpose. So that's, I think, quite simple. So I do, just before I run out of time.
Sorry, just before you run out of time, QI on this is not an issue in your view. Exactly. Possibly it could be raised on remand if we remanded.
Exactly. It's certainly not an issue in the briefs on appeal. So just very quickly, I wanted to touch on the two remaining claims. These are official capacity claims, and this is the set of claims that was addressed after the bench trial. These are the unreasonable search and unreasonable seizure claims. And I just think, you know, this case doesn't resemble the kinds of cases where there's a long line of contingency because of the testimony that was provided at trial. So at trial, McLane and others testified that there is, in fact, a policy in place that anyone in Tier 5, which is somebody who's living at home, can be subject to suspicionless searches at any time of day or night. So the only contingency that needs to happen for this claim, for this injury to occur, is that he needs to be released. And there's no dispute that he will be released at some point under the testimony at trial. As for the unreasonable seizure claim, the policy articulated at trial, McLane has unfettered discretion to order.
I'll
address anything else on rebuttal.
Thank you. Ms. Corbello, I agree with that.
Can everyone hear me?
Yes.
May it please the court, the SVP Act is a significant Texas statute that, according to this court, ensures the long-term supervision and treatment of an extremely dangerous group of people that are likely to engage in repeated predatory acts of sexual violence. The district court's dismissal of Hitt's various constitutional claims against Director McLane was appropriate to not only serve the purposes of this statute, but to remain consistent with both the Supreme Court's and this court's precedent in this area of law. Therefore, this court should affirm for 4 reasons. First, McLane was entitled to qualified immunity from Hitt's unreasonable searches claim against her in her individual capacity. Second, Hitt does not have a substantive due process right to be free from civil commitment or the realities of civil commitment as a sexually violent predator. Third, Hitt failed to demonstrate McLane's personal involvement in his unreasonable seizure and procedural due process claims against her in her individual capacity. And fourth, Hitt lacked Article 3 standing to bring an unreasonable searches claim against McLane in her official capacity.
Ms. Corbello, on the personal involvement, I'm just going to follow the order that your counsel opposite followed because I get a little confused with all the different claims. On the personal involvement, I mean, counsel cited 4 different record citations that show allegations, she says, of personal involvement of McLane in ordering various things. I guess, could you respond directly to that? And also, if we find that in fact there's been personal involvement adequately alleged, don't we just have to remand because the rationale for dismissing the claim appears to have been an error?
Yes, Your Honor. So I have written down those points. I think the first one counsel stated was that personal involvement was alleged because Hitt stated McLane had previously decided where he could reside. That conclusory allegation was based on nothing. There was no assertion of facts in the record that explained how she had been the one to individually, personally decide where he resided in the past.
He alleges it, though. He says, look, she's the one who decided. Why isn't that enough for just an allegation of personal involvement?
Well, Your Honor, as the director of TICO, if the allegation can simply be made that the director of TICO makes these decisions, then the director of any state agency, their personal involvement has been shown simply by the fact that their signature is somewhere on the paperwork that requires matters within that state agency to happen. The personal involvement allegation has to be contingent on the constitutional violation itself. Here, the constitutional violation is a matter of what occurred specifically on February 16th, not what occurred prior and not what occurred after. On February 16th, Hitt went to the TICO offices where McLane, the record shows, was not present, was not a part of the polygraph or any sort of seizure of Hitt and removal to TCCC, nor was she involved in any sort of the procedural due process violation that he alleges occurred on that same day. Again, the only allegations are for actions that McLane took separate and apart from the allegations he's bringing here, previously deciding where he could reside, again, that's conclusory, and also meeting with him on a different date 2 weeks prior, stating that she can decide where he resides, and visiting him after he was transferred to CCC, which, as director of TICO, and TCCC being the only facility that TICO houses sexually violent predators, is not so abnormal that it indicates she was personally involved in those decisions that took place on February 16th. If the allegation is that she's a supervisory official who's implemented unconstitutional policies, again, that's not enough to show personal involvement, like the district court found. The testimony at trial, for example, is that there were no TICO policies, and therefore she had not implemented any as to when or how reconfinement must occur. Those policies are a part of the SVP Act. That is what provides TICO the authority to determine where SVPs live. Nowhere in the brief or in the opening argument just now did Hitt's attorney state where in the record it shows that McLane's individual actions on February 16th or the specific policies that she implemented caused Hitt to be unreasonably seized or his procedural due process rights to be violated. And even assuming this court disagrees with that point, I think your next question was about reversal, Judge Duncan. And I do want to make the point, qualified immunity was raised as to both of these claims. I'm going to go back to this a little bit on the unreasonable searches claim, but just to preview it, qualified immunity was raised as to all individual capacity claims against Director McLane, including both the procedural due process and the unreasonable seizures claims here. And this court, according to Brewster versus Dreck in 587 F. 3rd 764, this court has a practice of affirming a district court's ruling on alternative grounds when those grounds are supported by the record. And here, the record very clearly demonstrates the assertion of qualified immunity against all individual capacity claims before the court ruled on that defense. In her motion to dismiss in the record at 146, McLane stated, quote, Hitt's claims against McLane and her individual capacity should be dismissed because she's entitled to qualified immunity, unquote. In the same motion in the record at 160, she states, quote, to the extent this court finds any claim to hold constitutional merit, McLane is entitled to qualified immunity in her individual capacity. She then raised the same defense in her answer prior to the ruling on the motion to dismiss, the answer to Hitt's entire complaint in the record at 217, that, quote, she asserts her entitlement to qualified immunity, unquote. In fact, in responding to that motion to dismiss, Hitt acknowledged the defense had been raised. He stated in the record at 283, quote, McLane argues that she is entitled to qualified immunity in her individual capacity, unquote. He made no argument at the time that McLane had only asserted qualified immunity to some of his claims. Instead, it was a blanket statement acknowledging that all individual capacity claims had a qualified immunity defense against them. In Schultia versus Wood at 47 F. 3rd 1427, this court made clear that so long as a public official pleads an affirmative defense of qualified immunity simply in his answer, the district court may, on its own motion, require a plaintiff to reply to that defense in detail. And that's exactly what happened in the court below. In its order, in the record at 533, the district court stated, quote, McLane has pleaded qualified immunity in both her answer and her motion to dismiss, unquote. And upon finding that, the burden properly shifted to Hitt to negate that defense. And he was given 2 opportunities to do so, both in response to the motion to dismiss, which he took by acknowledging the defense had been asserted, as well in objections to the report and recommendation. The only argument.
Let me just ask you this. I'm trying to understand your argument on qualified immunity in this appeal. And I'm looking at your brief, pages 9 and 10, which, to be honest with you, doesn't contain a lot of argument. Contains some case citations. I get that. Is that all you are arguing to this court on pages 9 and 10, or is there somewhere else in your brief where you're trying to flesh out the qualified immunity? Because I just don't see it.
No, Your Honor, I'll concede that the brief itself is not as detailed as my argument thus far has been, but I think the reasoning is sound. The court merely needs to look at the record in order to determine that qualified immunity was raised at every possible time, and the district court properly found that to be the case. Okay, and I also want to note that.
But I'm talking about the substance of the qualified immunity. Why should there be qualified immunity here? Why should I assume you're asking us as an alternative basis for affirming to do it on qualified immunity, or maybe it's not an alternative. One basis for affirming is qualified immunity, right?
The court could get there, although respectfully, the appellant did not raise any sort of argument against the district court's finding of qualified immunity. The brief is very clear that the issue appellant has is that the district court made a sua sponte dismissal based on qualified immunity. If the court reviews the appellant's brief, it will see that there is no argument as to whether both factors of qualified immunity were not met based on the allegations in the complaint. And there's simply no analysis to that effect. And so respectfully, that argument is not before this court and able to be decided. Again, I believe the record demonstrates clearly that the issue was raised.
Sounds like what you're arguing about is the allegations of personal involvement. That sounds like where the argument is being joined. Is that right?
I'm sorry, Your Honor. You're asking if the qualified immunity issue on the unreasonable searches claim?
I'm trying to figure out, I'm confused, obviously. I'm trying to figure out where the parties are joined their argument with respect to the Fourth Amendment seizure claim, the 14th Amendment procedural due process claim, and even to some extent the searches claim. Is the argument about whether the allegations are sufficient to show McLane's personal involvement in activities? Is that what we're arguing about here?
I do believe that if the argument about qualified immunity and its application to the unreasonable searches claim was something that this court could reach or decided to reach, yes, I believe personal involvement would be one way in which qualified immunity could be found, because just like the unreasonable seizures and procedural due process claims, there have been no factual allegations as to how defendant McLane participated in any of the searches that Hitt complained of. Again, that's not what appellant has argued to this court. Appellant is simply arguing that the district court acted improperly in making a sua sponte dismissal on the basis of qualified immunity, not that qualified immunity was analyzed incorrectly in any way.
Okay.
Does that clarify it, Judge?
Not really.
Somewhat.
I thought the personal involvement argument was distinct from qualified immunity. I thought it was, well, there haven't been allegations that she was personally involved in any of these things. Therefore, that couldn't support 1983 liability on behalf of interpersonal capacity. I thought that was the argument, and we were supposed to look at the allegations and see whether it was properly alleged.
So for the unreasonable seizures and procedural due process claims, my understanding is that's what appellant would like the court to do, is to look at the allegations of personal involvement.
Right.
I will point out that
are not sufficient.
Correct. This court requires distinct factual allegations about the constitutional violation itself, and I don't believe that there's any case law for the basis that allegations about what occurred on different dates unrelated to the events at issue in this case are sufficient to show personal involvement.
Okay.
I just want to note for the court that sua sponte dismissal on the basis of qualified immunity is not the basis for a finding of abuse of discretion in this case. Plenty of appellate courts, the 3rd, 4th, 8th, 9th, 10th, 11th, have all affirmed district court dismissals where sua sponte dismissal has occurred on the basis of qualified immunity. And they do so because 28 U.S.C. Section 1915 E2B, which governs IFP complaints, requires district courts to screen for claims that, among other things, seek monetary relief from an immune defendant. This court can make a similar ruling, and it doesn't have to go far to do so, given its ruling in Bohannon at 527 Federal Appendix 283. In Bohannon, this court allowed a district court to sua sponte screen an IFP complaint and dismiss that case based on sovereign immunity, specifically because Section 15 allows this. Given this court's interpretation of Section 15 and the fact that it is exactly similar to the other appellate courts that have already found this, sua sponte dismissal on the basis of any immunity defense, including qualified immunity, is assuredly permitted under Section 1915 and was allowed in this case where, at the time Hitt filed his amended complaint, he was an IFP plaintiff.
If you could give, I don't know if you have anything else on that, but on the substantive due process claim, counsel opposite says that it was error for the district court to say that those claims are coterminous with the procedural due process. Meaning,
right. So
cases that say, well, you do have a substantive due process right with respect to, for instance, why you're being confined and with respect to the GPS monitor, which that sounds plausible to me. What's your answer to that?
Sure. So that was, thank you for getting me there. The substantive due process claim, I want to point out first, in the amended complaint in the record at 78 to 79, which is the substantive due process section, there is no claim of a violation of a substantive due process right for the failure to make reconfinement in TCCC contingent on a medical provider's recommendations. And similarly, there's no allegation that GPS costs violate substantive due process rights because they lack any sort of basis in medical treatment. And so one of the arguments I'd like to raise is that substantive due process was not argued on either of these bases and should not be before this court. Even if this court reaches those arguments, however, I think Brown at 911 F3rd 235 is the case to rely on. There, this court made clear that it does not violate substantive due process for sexually violent predators to be subject to civil commitment. And that holding was based specifically on a finding that sexually violent predators, that the SVP Act itself serves two government interests. First, providing treatment to SVPs so that they may potentially return to society, and supervising sexually violent predators so that society is protected and secure from their dangerous tendencies. In order for this court to reverse on the substantive due process claim, it would have to find that a government action did not comport with substantive due process because the actions were not rationally related to a legitimate government interest. And that simply can't be found here on either basis for the substantive due process claim. Hitt did not have a right to substantive due process for movement from community placement to reconfinement in TCCC to be based solely on medical discretion. As appellant acknowledged herself, the Sexually Violent Predator Act serves both security and supervision issues. I think appellant made the argument that there was no rationale for transferring him to TCCC because it didn't serve any supervision purposes, and that's just absolutely not true based on the record. The record is very clear that Hitt lied to TICO officials about a consensual relationship with a woman, a relationship he was required to disclose, and he decided not to do so. The security issue becomes even more of a legitimate government interest if the court considers that this woman had a minor child residing with her. Again, something that Hitt is required to disclose and he didn't. This was a clear security concern not only for the community he lived in, but for the minor child herself. There is a government interest established by the Brown case in security, and therefore Hitt's removal from community placement back to TCCC clearly served that interest, and there's no basis to find a substantive due process violation on those grounds. The GPS monitoring is, the court can reach a similar sort of finding. I think Hitt argues that the payment of his GPS monitoring costs does not serve a medical treatment purpose and therefore violates his substantive due process rights. But again, this ignores the second legitimate government interest that the Sexually Violent Predator Act and its provisions serve both security and supervision. There doesn't need to be a medical basis for having to pay these costs because GPS monitoring clearly serves a security purpose.
How does it serve a security purpose when he's confined as he is at the facility?
Your Honor, these are people who have been deemed so unable to control a desire to engage in repeated predatory acts of sexual violence against other people that they've been civilly committed. There's no basis to find that GPS monitoring, in addition to cameras that catch as many angles as one can possibly catch in a facility, those sorts of security measures are more than rationally related to a government interest in security. It's the security of the sexually violent predators.
I think you misunderstood the question. I understand as a general matter why GPS is relevant. My question was why, when he's in a tightly confined facility as he is now, why is it relevant to security where he is now?
Because of the nature of their offenses, Your Honor. These are all sexually violent predators being housed in the exact same facility, being required to interact with each other at any given time. They also are required to interact with security at TCCC. GPS monitoring offers an additional level of security that cameras that are only able to catch certain angles, and that I think the recent storm in Texas have demonstrated to us technology can be flawed at any moment in time.
Okay, so you're
the second layer of security. I'm sorry?
You're saying that the GPS monitor is used while he's in this facility to monitor his movements. Is that correct?
Yes, Your Honor.
Okay.
This is not in the record, but the GPS monitoring is only provided to the sexually violent predators within TCCC who are lower level in the sense that they're more likely to attempt to flee the facility as well.
Okay.
If the court has no further questions on the substantive due process piece, I'd like to move just quickly to the Article 3 standing portion. If I could have just an additional minute, or if the court would like, I can.
Yeah, 30 seconds. You may have 1 minute.
Thank you, Your Honor. I would just like to point out that Article 3 standing requires a clear, immediate, and likely threat of the claimed injury. There is no claim here that demonstrates such a likely and immediate threat. The speculative starting point that Hitt may at some time in the future be placed in community placement again and then subject to the same searches he complains of is just that. It's entirely speculative. I would refer the court to the statute itself. Nothing in the statute even requires Hitt to go back to community placement before he is released completely into society. That can be done after a biennial review by TICO, as well as if he petitions the court and that's granted. And so there is certainly a world before him where community placement isn't even a reality, much less a likely and immediate reality. And to the extent this court disagrees, again, the likely and immediate threat has to also be tied to the searches itself. Nothing in the testimony at trial, specifically Volume 1, page 64, demonstrated that there was any policy within TICO as to how searches for Tier 5 offenders need to be done. This court should affirm the district court's rulings on all grounds. Thank you for your time.
Thank you, Ms. Corbello. Ms. Datla, you have saved 4 minutes. We'll give you one additional minute. Not that for the minute I gave Corbello. You have 5 minutes on the vote.
Thank you, Your Honor. I think I'll take the arguments in the order that we've been discussing them, but at the outset, I think, it's there were a lot of new arguments in my friend on the other side's argument, and it's perfectly understandable why, given the way that the briefing interacts with each other. But I think this is a case where the defendant has had multiple opportunities to make arguments, and the arguments that we were pressing in the opening brief were quite clear. And where the defendant chose not to respond to them in the briefing and thus chose not to give us a chance to respond in the reply. The proper thing to do is to take the argument as it came to you on the briefs. And the basic way to understand the briefing, I think, is that we identified the bases for the district court's opinion and explained why they were wrong. And the appellee rested solely on the justifications given by the district court. And I think those are the arguments. The simplest way to resolve this appeal is to address those arguments. And as Judge Duncan's questions have pointed out, because this case will proceed, there are other ways to raise various arguments that the appellee would like to raise now at later stages of the cases. So I'd like to start with the two individual capacity claims, the unreasonable seizure and procedural due process claims. These are the claims for which the real dispute between the parties here is whether or not the complaint adequately alleged McLane's involvement. And I just don't think that my friend on the other side is applying the proper standard under Rule 8, which is that you have to plead facts that plausibly allow for the inference of what you're alleging. And that's what happened here. McLane is the director of this organization. She threatened to do something. That action occurred. And then she visited him, and when asked to explain why that action had occurred, said, I don't really have a policy in place that justified it. The reasonable inference is that she carried out the threat. The fact that she wasn't there is irrelevant, because the test is not whether she participated in the actual seizure. The test is whether she had the authority to order the action that's the subject of the constitutional violation. And there's simply no reasonable inference that you could draw that some random person unnamed in the complaint and undiscussed today made this decision and that she sanctioned it after the fact. That's the kind of inference that you don't draw at the complaint stage because it's an adverse inference. I would like to note that counsel, my friend on the other side, said that no discussion of qualified immunity was raised in the opening briefs as to these two claims, and that's just incorrect. We explained at pages 38 and onwards why we think these two violations were clearly established. And you might draw an inference from the district court's decision that he thought these violations as alleged were in fact so obvious that that's why he didn't rule on qualified immunity on these grounds, but instead went to the personal involvement rationale. So I think taking then the next claim, which is the unreasonable searches claim, the dispute here, the only new argument that was raised that I think I should respond to is that my friend on the other side suggests the district court's decision can be justified under the screening provisions of the PLRA, and that's not what the district court did here. It's not an argument that was raised in the briefs, and it doesn't excuse the failure to brief the qualified immunity issue, to seek to dismiss this claim at all below. The fact that as to the claims she raised, she did raise a qualified immunity defense is not a dispute. The dispute here is that she chose not to seek to dismiss the unreasonable searches claim, and so it's not at issue. On the substantive due process claim, I think the only thing that needs to be emphasized at this point is that these two claims are being assessed at the motion to dismiss stage, and counsel's numerous justifications or explanations after the fact have no basis in the complaint. And I'd also just add that they don't have a basis in the record that was developed at trial. For example, at trial, the justification given was not, I thought that this was a dangerous situation for Ms. Lopez's child because communication had been cut off by that point. The justification given by McLane in her actual testimony, which is cited in the opening brief, is I just had this feeling that I needed to bring him in because something had gone wrong. That's not a community danger finding at all. And finally, as to the standing arguments, I'm not quite sure I understood my friend on the other side's argument. I took it to be that maybe he would be released. He would skip the step of being released into the community and be released from civil commitment altogether. That's a new argument that I think doesn't have a basis in the record. I think what the record shows, this is at record 127 and 128, these sites are cited in the opening brief, is that McLane admitted she had a policy that authorized these searches. So the only thing that needs to happen here is for him to be released again. McLane admitted that she has a policy as to the seizures, and the only thing that needs to happen is that he has to be released, and then she has to act on that policy. So I think, again, this is a fairly simple case on the briefs, and we'd ask you to reverse for the reasons given in the briefing.
Thank you. This case will be submitted, and all the cases will be taken out of data And this panel will adjourn without date.